welcome back to another edition of the Dirty Verdict Podcast. I'm one of your hosts, Peter Taaffe, joined as always by co-host Kyle Herbert.
Peter, I just can't tell you how glad I am to be here.
And we get to talk more today because Bill is not here. He is traveling for work, so there's going to be a vacuum of noise for.
We can drop in some Bill comments later, like in post production.
We can because we took so many out that we can just put them back in.
A lot of people don't know this, but a lot of Bill that you get is actually hydrogenated oil and fat, and then a lot of like post production lasers and audio.
Yeah.
So he's mostly Disney at this point.
Yes.
So Bill, we miss you, and we'll have you back soon. But in the meantime, you're a hologram.
Yeah, I'm over there.
Yeah.
Okay. Before we introduce our esteemed repeat guest, couple housekeeping matters. The cake, that is a cake in the middle of this table, and that is to honor
massive cake.
That's to honor our producer, Amanda Orr, whose birthday is, of course, this is her birthday month, but we celebrate this one today. She's
happy birthday, Amanda.
Happy birthday.
A very sprightly 28.
I think her age is a top secret.
Mystery wrapped in a conundrum.
Yep. And
wrapped in a crepe. I'm thinking 27, 28 is probably as close as we'll get.
Anything I would have said would have been probably offensive or totally unintentionally offensive, but it would have been.
It's fine.
You just can't ask.
Okay. All right. And also close to the mic, too. Just be careful. There we go. Okay. Our esteemed guest, none other than Ryan Pigg.
Our Pig.
Of the Buzbee Law Firm. Thanks for joining us again, Ryan.
It's hard for me not to say that'll do, Pig.
Well, thank you all for having me, and you, like everyone else, can just call me Pig.
Very good, which I always do.
Right.
Ryan, you guys had a massive verdict last week.
Massive.
What I want to know first is, so we don't need to talk about your background and other stuff because we've interviewed you before, and you've been a friend of the show and been on the show before. So tell me, what was your role specifically? This case was a crane collapse. Specifically, what was your involvement in it, and what role did you play at trial?
Yeah, sure. And first, thank you all so much for having me. I was thinking to myself in my mind when the verdict came out, the first person I wanted to tell was my dad. And then about the second and a half thing I thought about was I've got to get back on the dirty verdict to talk about this. So
we're super happy to have you. We really appreciate that.
Thank you all. So my role, I was brought in last summer, right before the original trial date, which I believe was September of 2024, to help with the significant amount of legal briefing that was dumped on David Bergen. They filed every MSJ, every motion to strike expert, special exceptions, like you name it. If you can file it as a defendant, it was filed. And David Bergen's a fantastic lawyer, but for one person to handle all that was just too much. So Tony brought me in, said, help him with the briefing, help with the case. And then if and when we go to trial, I need you there to assist with that. So we got over the briefing. We beat him on everything as we expected we would. And then unfortunately, Judge Englehart had a medical condition, a surgery come up, which forced the court to punt the trial date, which was reached earlier in April. So going to trial, my role primarily was to handle witness prep, to handle all legal objections that would come up, and then kind of assist with the charge and assist with ancillary, I guess you would call it case law things, to make sure that our train stayed on the tracks and we weren't creating error or other issues that could hurt us later on.
Yeah, let me ask a simple question. So the defense had Daryl Morey on the other side as appellate counsel.
Just Daryl Moore.
Did I say Morey?
You said Morey, the former GM of the Rockets, but that would have been badass.
I mean, Morey sounds really esteemed. But
yeah.
Excuse me.
It is Honorable Judge Daryl Moore, who was the appellate.
So former Judge Moore.
Yes.
Was on the other side handling appellate issues as they came up for the defense.
Correct.
Did you feel like it was your job as to mirror him, or perhaps a broader role for you?
A little bit broader than his role, but certainly anytime Judge Moore stood up, I knew it was my responsibility to also stand up and handle it. And Judge Moore is a fantastic lawyer who works at a very good firm. And my instruction was clear. Tony basically told me, Pig, go in there and throw 100 miles an hour every time you stand up.
Okay.
That's what I tried to do.
Great.
Okay, but I think we kind of jumped into the meat. I always like to kind of frame the issue for everyone.
Peter, I don't want to step on your toes. You are the professional.
No, that's fine.
He is at the head of the team.
You are the professional at setting the scene, and I will withdraw so you can.
It's
do that.
okay.
Excuse me.
No, it's good. It kind of keeps it moving. So let me frame the story. So
Yeah.
The story is obviously Tony Buzbee was lead counsel. David Bergen, who you referred to, had done most of the prep work up until by himself or with Tony's help.
Correct.
Up until last summer. And then you came in to assist as it was prepping for the trial. So the case was against TNT Crane Companies.
So I'll just give a broad overview of the case. It involved a crane collapse of a air handler unit, or as normal people would say, an HVAC unit, for a commercial building at the Texas A&M San Antonio campus. It was being flown into the 4th floor of the building. It weighed over 5,000 pounds. It was irregularly shaped and also very top heavy on one side because of the way it's designed. All the coils are on one side. So you have a lot of weight on the top right, so to speak, of this air handler, and then not a lot of weight at the bottom. As it was being flown in, certain decisions were made about the unrigging of that air handler unit, which was being supervised and directed by TNT. Essentially, it was hooked to the crane by 4 shackles. 2 of those were removed. And after those 2 were removed, the only certified rigger, TNT's rigger, on the floor with the radio, who was able to communicate with the crane operator, made the decision while 2 men were in what's called the fall zone or the danger zone to rig up or lift up the unit while it was halfway rigged and with 2 men in the fall zone. And as it was being lifted, a gust of wind came, and the unevenness of the load compounded with the wind caused it to fall over on both those men. One of the men lived after they lifted the unit off of him, but unfortunately the byproduct of lifting the unit off of Mr. Montalongo was the unit's corner that Mr. Loree was under actually went down more. So he was, not only crushed the initial time by the first impact of it falling, but the crane, the way that it was lifted and still rigs, it basically pinned and crushed him even more against the concrete as the other man was able to escape. And he died about an hour later. So the case leading up to trial was against TNT, the crane company, who was responsible for the lift and were the subject matters experts of the lift. Byrne Construction, which was the general supervisor of the entire project and had been contracted by A&M to handle all aspects of construction, including the installation of these HVAC units. And then David Loree's company, which is called Way, and there were subparts to that, and I'll spare the nuance because it's kind of boring, but the easiest way to think of it is Way was his employer, the deceased employer, and they were specifically in charge of HVAC and pipe fitting. So right before trial, actually on the eve of trial, we settled with the Way defendants and also with Byrne, leaving TNT as the single defendant that the jury would actually see and hear from during trial.
And okay, so his employer would have been normally comp barred, but under Texas law, if there's a wrongful death and you can establish gross negligence, you can pursue a claim against the employer. That's
correct.
Situation.
So there were 2 Way entities, mechanical and engineering. He was payrolled and employed by engineering. Our argument was that we had a traditional third-party case against mechanical because they were not his employer. They argued borrowed servant. I handled the briefing on that, and we prevailed. The court felt that there was a fact issue concerning his employment status. So had we continued with them at trial versus settling, that would have been a core issue in the case, is trying to establish that only Way Engineering was the employer so that Way Mechanical could not get the benefit of the exclusive remedy defense, thereby destroying an ordinary negligence claim against them.
And then David, who did he leave as survivors?
He left his widow, his 2 sons, and his mother.
Got it. All right.
How close did you guys, I know you can't discuss numbers. How close did you guys get to settling with TNT? Seems like he had everybody at the table, basically all the facts. I've heard Tony talk about this before, who says don't leave anything on the table during discovery, give him everything you got, fight it out then. Was there any desire on TNT's behalf to try and get the case done short of trial?
There was certainly desire, but we were far apart, and to my surprise and shock, right before trial, they actually went further apart, meaning they went backwards.
Really?
And
they thought their case got better as you put a jury in the box?
I know that move was made a week or two before we even did Vordire. I think it was more a message of...
They were relying on the idea that you had settled with other parties and had gotten paid?
I think it was more of a send a message to Tony of we're tough and brash too, and we can do things with our money. You don't get to decide everything. Okay. And obviously that message wasn't received well. And I just think, when defense tries to do those kind of moves of going backwards and settlement negotiations, I don't understand why they do it. It never works.
Well, if the goal is to settle the case, certainly moving backwards doesn't do anything to move it.
Right.
So as far as their team, Kyle talked about former Judge Daryl Moore, who's very respected appellate lawyer.
Very much, yeah.
Yes.
Was on their team, and then they brought in a kind of a trial lawyer to lead their trial. How close to trial was Mr. Kim brought in?
I think he was brought in right around the time that they went backwards in the settlement negotiation, so it had been just a couple of weeks before.
So they literally had a completely different defense team up to the point of negotiations, and then on the eve of trial, they brought somebody new in?
Yes, Marilyn Volandos and Susan No Wilson handled the case from Genesis to right up to trial, and then that team changed very dramatically in the weeks leading up to trial.
Do you think that was strategic or desperate? Or if I see somebody, changing out barrels, changing out guns, changing out lawyers with 2 weeks left, I normally think, well, they've lost confidence in their team. Or did you get any sense of what was going on?
Yeah, we see that a lot. I think defense lawyers call it parachuting into a case. I think that's the term of art that they like to use. And some people hold themselves out as being these advocates that are able to jump into a case at the last minute and, quote, right the ship or do a better job than the existing counsel.
Whole new evaluation to try and fix the situation.
I mean, from my perspective, I always see it as desperation.
That's how I would see it.
You've had a team work on this case for 3 years, and you're basically telling the other side that whatever that team did for 3 years, you're not confident enough in them to take it to the finish line. That you need to bring in a random person who doesn't have the institutional knowledge, feeling, or understanding of a case that's been generated over years to basically save the airplane from running into the mountain. That's how I interpret it.
It's incredibly difficult to get a team of lawyers, no matter how talented, up to speed within 2 weeks.
There are very, very few people that can do that.
So there's a couple of reasons why they'll do it. Sometimes the excess carrier will get the case tendered to them, and they work out their own particular lawyers they want, and they're willing to take the risk that the lawyer may not be as intimate with the facts and that's fine. But in this case, I think, didn't Mr. Kim tell the jury in the punitive damages phase that the chairman of the TNT company had hired him to do this?
I can't remember, and I don't have the record in front of me. It had been a long 4 weeks at that point. I don't remember exactly what he said, but I do remember some reference to that. Certainly talked about that he and his wife were brought in very late, which I guess was his attempt during the punitive phase to try to wash his hands of what had happened a little bit. But yes, there was some suggestion that TNT had a role in selecting him personally to try the case for them.
Okay. And then, let's talk about, we'll get into the liability side. So Tony, it looked to me, a lot of us watched it. He pretty much took every witness except for the depositions, which I think David Bergen had taken and deposition excerpts were played. But as far as live witnesses, was it Tony doing all of them?
Tony handled every live witness. We met about that as a team beforehand. Obviously, there's a lot of really talented people on our team. And we had a conversation, and Tony said, I strongly believe that this case has the makings of something special, and is of no offense to you all of you are very capable lawyers, but I want us to have our best shot at doing something special with this case. So I would like to do all the witnesses live. And then David Bergen, for over the course of 3 years, had taken, I think, right around 30, 35 depositions and did a phenomenal job. Many of those deposition excerpts were absolutely critical to what we were trying to show the jury over the course of 4 weeks. And he, even though he wasn't doing it live, it was him laying the foundation for a lot of the things that Tony needed and wanted to do. And he did a great job.
Good. And so y'all's theory was obviously at trial was TNT subject matter experts. They know how to handle loads, coordinate this, and they were the sole cause.
They were the subject matter experts. The lift was still being performed at the time that this man was crushed and killed, and that they had the absolute duty and the onus was on them to make sure that the lift was performed safely, and they failed. And one of the things we struggled with, at least from my perspective, is their failures were there was so many failures. It was hard for us to decide, well, how do we make this more concise so the jury can actually sink their teeth into it? And at one point we had a blow up of, I think at the top of it said TNT's failures, and it was a list of 17 things. And any one of those 17 things in a normal case could have won you the case. But we tried to narrow it. We tried to, what we believe, thought would be the most powerful liability facts, and tried to really focus on those 3 or 4 things that we thought would lead us to the greatest liability chances.
And which were those?
Instructing the crane operator to lift while 2 men were in the fall zone, directing the unrigging activities and unshackling half of this load, even though you knew it was top heavy and uneven, and then their knowledge that it was top heavy and uneven because it had fallen in their yard the day previously.
Wow.
And that they sent vice principals, the term of art lawyers use, but basically managers, to the lift that day because they knew that air handler unit was dangerous as hell. And during the case, I think this happens in a lot of cases, once you start getting the feeling of kind of where the train is going, certain documents become more important than perhaps you thought that they were previously. And in digging for something else, I kind of stumbled upon, because again, I was newer to the case, some text messages that these vice principals were sending to each other literally 40 minutes before this man was killed. And what they were doing was photographing the first unit being lifted onto the 4th floor. And you could see from the pictures that this first unit, which was still top heavy and uneven, but less so than the one that killed Mr. Loree, it was swinging back and forth like this. You could see it in the pictures. And they were discussing amongst themselves, they should use this cantilever, which is a safety device, which would have made it safer to do it. And I think the exact verbiage was, that thing looks really hard to lift. And you basically have these managers acknowledging that what they were doing was risky.
Not super safe.
Not super safe. And instead of calling a stop work, instead of bringing it back down and saying, you know what, guys, we need to use this cantilever bar. We can't do this safely. I'm seeing it swaying. This is a bad idea. Those same managers that were sent there to observe this load being lifted just drove to the parking lot while it was still being lifted and didn't bother to do it.
So I watched a fair chunk of the trial, and I got to be totally honest. This was an expert-heavy trial. And at some point, I was like, yeah, I can't listen to another 3 hours of crane lifting engineering experts. So my question is, at what point do you feel like the trial shifted in your favor? That's question 1. And question 2, a lot of lawyers kind of out here in the gallery to me have said, when the other side admitted the exact same failure had happened 24 hours before, the jig was up. And everything after that was kind of gravy. And so my question is, when do you think the trial shifted in your favor? And 2, do you think that most of the lawyers watching at home were correct that when they said, yeah, the exact same nightmare happened the day before, that's when the jury was like, yeah, come on.
Yeah. I think there were two moments in the trial where it really felt like liability wise, we gained significant momentum. The first was Susan did the opening for TNT. And to her credit, I thought it was very well polished. I thought she was well spoken and had the things she said they could actually live up to or were true, then it would have been an excellent opening statement. The problem was she made promises
she couldn't keep.
Yeah. And that's trial 101.
That cuts your own throat from day one.
Right. If you're going to stand up in front of the jury, especially in opening, you're going to make promises to them about what the evidence will show or will not show. You better be damn sure that you're right or 99% right. And in the very beginning, she said, I think the verbatim quote was, wind had nothing to do with this case, had nothing to do with knocking the unit over. And just by coincidence, our first witness, Alexis Perez, was the guy standing on the opposite corner of the unit as this horrible incident happened and had the best perspective as to what the wind was doing. And within the first 2 minutes of Tony directing him, he asked him, was it windy up there? Yeah. Did you feel the wind gusts on your back? I did. What did the wind gusts do? It came in and it blew the unit right over. And Tony had this moment, a Perry Mason moment, whatever you want to call it, where he turned and he just stared at TNT. And it felt like forever, but it was probably only about 5 seconds. And it was just this really powerful moment setting the stage of everything these people just told you is either a lie or a half-truth. And we nailed him on that. We used that opening statement for 4 weeks of nailing them over and over again about certain things that they represented to the jury.
What's the wind meter called?
I'm gonna butcher it. Anometer.
Anometer.
We called it wind gauge because that word is just.
Well, in his closing, he said 3 or 4 times, "How much money will it take for them to put an anometer at the top of this structure? Right. How much longer will we wait for them to do this?" I thought that was very powerful.
Yeah, absolutely. Tony's framing of the compensatory damages and the punitive damages was brilliant in my view. The way he framed the value of human life in explaining without violating the rules or without running afoul what the case law says is these are compensatory in nature, but you have to send a message that in Harris County, the value of human life is extraordinarily high. Otherwise, they will continue to do things the same way that they always do them. Because if you send the message that the value of human life is not extraordinary or even low, as TNT would suggest that it is, then they have no incentive whatsoever to change anything that they're doing. So the onus, the duty is on y'all. I think Tony even used the word, the duty is on y'all to show them that the value is very high.
So my next question is, I watched the full closing for the compensatory damages for the liability portion of the trial. What was his focus? How did he, for those listening at home, you guys got $180 million on the first piece.
160.
159.
159, 160, and then a much larger award on punitives. What was the thrust of the argument on the punitives, and why do you think it was so effective?
I think the punitive, for 2 reasons. I think one, the way Tony framed compensatories and punitives was again brilliant. That was the first thing I told him when we were walking to my truck afterwards, how he did this, of saying, y'all awarded $160 million in compensatories. And he made this chart and he said, if you do $25 million in punitives, when you compare those two things, basically what you're telling them is, in Harris County, the value of human life is very high, but we don't think your conduct was that bad. If you do $50 million versus 160, the value of human life is very high, but your conduct was only kind of bad. And he created this comparison, which basically showed them that if you don't do 2x, 3x, or 5x, you're basically counting their behavior, that this is not about compensation. This is about showing them where it hurts most, their pocketbook, that their conduct was deplorable, that their conduct was extremely dangerous, and that it was indifferent to human life, and that you better not do it again because we're going to punish you. We're going to try to deter your conduct. And that framing of that argument against what anyone would consider very high compensatory damages, I just thought was so smart, because when you think of it that way, you're like, gosh, we really do have to do a big number. Otherwise, in light of how much we value human life, we're basically saying that their conduct wasn't that bad, which it was.
What was the punitive number?
480, I believe.
That for the total, right?
Total.
So the punitives were 300 and something.
No, the punitive was 480.
The punitives were 480. The total verdict was 640.
640 million.
Yes.
All right, let me ask one more dumb question before you jump in, Peter. Lots of times we talk about how important voir dire is to a case, and I've tried enough cases, so has Peter, to know that that's really the first building block. Was there something about voir dire that you felt like was really effective looking back on the massive verdict that you got? Or was it just like luck of the draw? And I know you're not going to say it's luck of the draw, but like, what was it you guys focused in on getting 12 people that you felt like were going to be effective jurors for this case?
Well, a lot of work product in picking lots of juries. There's some science, I would like to say, behind the types of questions that we asked them, and the themes that we present to them from the very beginning. But Tony was clear with them from the first 10 seconds of standing up that the evidence in this case merits awarding a lot of money, and I need to know which of y'all are uncomfortable with that, even if the evidence supported it. And the case law on that's clear is that, bias and prejudice can stem from damages. And that there are some people that, regardless of evidence, even extraordinary evidence like we have in this case, that they just flat out will not award mental anguish damages.
Sure.
Or they'll say, you know what, death of a husband, of a father, of a of anyone, we don't care. It's $250,000 for pain and suffering, mental anguish. I'll never award more, no matter the evidence. And Tony spent, I would say, 95% of voir dire talking about those issues with people, saying, I need your brutal honesty, and I want y'all to be uncomfortable with me and talking about money and talking about the value of someone's life. Those are two topics that most people do not talk about in their ordinary lives, and when presented with those things, don't want to talk about it. And I think he was artful in explaining to him, we must talk about it, and this is very important. And that opened their mind to the very beginning. The whole panel, 100 people sitting there, saying, wow, this is a big case, because he keeps talking about these huge numbers.
Prime the pump.
Priming.
How many got struck for cause?
Oh, not that many. Our judge came from a criminal background, and they're always harsher when it comes to cause strikes. So we really didn't have that many.
Who was your trial judge?
Judge Erica Hughes.
It's like I tell every judge, just give me the first 12 honest-looking folks.
That's right.
Yeah, so Judge Hughes took over. She, I guess, beat Judge Englehart in the primary, and so taken over effective January of this year. Okay, so as far as their defenses, you talked about the opening and some of the things that were said. Tony, and we can get into this next, is Tony posted on social media pretty quickly after the verdict, said they blamed David, the deceased, for everything, and they hadn't before, up until trials. I think that's what was said, before, or maybe that was a closing, and maybe.
Yeah. I think he said in closing.
Yeah.
He said at open, they said this was not this guy's fault, and then they stand here today, they say 100% it is.
Yeah. So what was their defense? Basically, what did they try to convince the jury?
Yeah. So kind of two questions in there, and you're touching on something I spoke about before of making these promises to juries or representations to the jury that were either untrue or they just flip-flopped on. And blaming David Loree was like probably their biggest flip-flop in the whole case. John Kim stood up and said, we're not going to blame this man. That's not our strategy. And then their corporate rep gets on the stand and says, I think David Loree is 100% at fault. And then John, in closing, says, I want you, how did he phrase it? I want you to write no under David Loree, but I want you to put all the blame on Way Engineering. Well, the only way Way Engineering would be at fault is through the vicarious liability of
their employee, David Loree. Yeah.
Right. Why did the corporate rep think it was his fault?
He said because David Loree was ultimately the one that gave the instruction to lift up on the air handler unit. And our point was, well, that's fine to give the instruction, but you need to do it when it's safe. The air handler unit needed to come up. No one disputes that, but you don't do it when it's halfway hooked up and you have 2 men in the fall zone and you know that thing can fall over. So that flip-flopping, another example of that was saying for question number 1, John Kim told the jury, write no for the negligence of TNT. But for question number 2, go ahead and put 5% of the fault on TNT. It's like, do you think this jury's stupid? You just told them to put no for the negligence question, which means you would not put any percentage on TNT.
I mean, you're specifically directed in the charge only to answer people you said yes to, right?
So let me ask another dumb question.
Yep.
If I'm a defense lawyer, which I was for like 2 years, 25 years ago, my goal was always, is this a covered claim? And then who else can I blame? Find other defendants. And clearly there were other liable parties because they settled with you. How good a job did the defendants, TNT, do of pushing blame out to people who had already essentially admitted liability by their settlement?
Right. So that kind of dovetails off of what Peter was asking. That their case was to blame Way and then in a cute way blame David, who he was working for Way. And the method in which they attempted to do that was through explaining that the skates are basically these like giant roller squares on the ground, that by setting it, the air handler unit onto those skates and then using a come along to pull them, that basically they tip the unit over onto themselves. In terms of effectiveness, I think they're flip-flopping between of blaming David Loree and blaming Way and then calling the skates Jenga. It felt disorganized, and the numbers reflected that. They put 27% on Way Mechanical, but the lion's share of the fault went to TNT at 68%, I think was the number, and Byrne was, I think, 2%.
So Byrne, because the theory against Byrne was like, you're the traffic cop, you're the coordinator of everything. Something bad happens, it's because you weren't minded. But it would be hard for TNT, I would think, to blame them because they're like, they would be saying, you didn't supervise us and we made a mistake because you weren't supervising us. So
it felt pretty quickly into trial that they gave up on trying to blame Byrne, that the focus became solely vacillating between Way and blaming David Loree. And then when they realized it was going to bite them in the ass to blame David Loree, they tried to then shift it only back onto Way. But at that point, it was just so muddy. I don't think their presentation was effective. And clearly the numbers reflect that.
Did they give a number for the jury to say, look, if you do still blame it all on us, here's what you should award?
In terms of damages or percentage?
Yeah, damages.
Yes, they said, and again, it goes back to the flip-flopping, because John stands up there and says there was no conscious pre-death pain and suffering of Mr. Loree after the unit fell on him. But then he goes, well, go ahead and award $100,000 for that damage.
Just in case there might have been.
Yeah, so either there was or there wasn't. You got to stay in your lane. And
but I assume you had plenty of testimony that said he was.
There was testimony of his eyes being open. He was still breathing. Alexis Perez said that he did CPR and it seemed like he came back. He wasn't declared dead until an hour later. So yes, there was evidence that that he was still alive and may have suffered after the unit crushed him.
How about did they give numbers for companionship loss of for the parents and wife and children?
They suggested numbers for every category of damage, but it made no sense in light of their core arguments of these things shouldn't be awarded or these things are not valuable at all. It just felt very disjointed and not sincere. I think their case suffered significantly from that. There was just a lack of sincerity in what they were saying.
Yeah. And when the jury came back your way, what was the feeling like in the courtroom on your side? And then also, if you perceive what was happening on their side.
I think on our side, it was overwhelming. This team, not myself, but at least David Bergen had worked on this case for years. T&T's position had always been, we didn't do anything wrong, and even if we did, we don't think this family deserves a lot of money. That was another component of this case, is it was very clear that T&T did not think that the Loree family was worthy of a lot of money, that there was a superiority in their attitude towards these folks that the jury, in my view, picked up on in arrogance. And from our view, I think it was relief and happiness. And these were good people that had this horrible thing happen to them. As Tony said in his closing, this man was killed in one of the most violent ways that someone can be killed, through gross negligence. And to finally have 12 folks from our community agree with us on all these things is such a rewarding feeling. I mean, it's why many of us do what we do, because we are so passionate and feel so emotional about these cases. To then have your community say, we agree with you, that's very powerful.
And they also found, which is very unique in our world, finding of gross negligence. The standard is very high.
It's very high.
So they found yes on gross negligence, which meant y'all are got to come back the next morning at like 8:00 and argue to the same jury punitive damages, which is the only way you get punitive damages is if you get a gross finding. So what was that like, having to rush back and or I guess do some immediate prep?
Yeah, I've never been in that situation before. I've been trying cases with Tony for 10 years, and I've never done a bifurcated case before. A bifurcation, meaning that the damages part of the punities are split off. They have to find the liability first, as you explained, and then you come back for the second phase. And we workshopped it. We talked about it as a group, and we decided we think the most effective presentation has already been done, that they've already seen the liability. They've already seen why this company should be punished. We don't need to bore them by going over stuff again. And we certainly don't want to risk this corporation getting up there and finally doing the right thing, saying we really screwed up and we're so sorry. Please, God, do not punish us. We're going to do the right thing. We thought it best to avoid all that and just do another closing argument the following day, a very abbreviated closing argument with a scope of review of just punitives.
And they weren't gone long on the punitives. It was a couple hours.
It was an hour and a half.
Yeah.
I didn't watch the punitive argument. How long did Tony go on that presentation? I'm assuming it was largely a rehash of his first close, laying out a different set of parameters for how much money would be appropriate. Did he go 20, 25 minutes?
Clearance.
Yeah.
And again, focusing on the instructions themselves, would say these are not compensatory in nature. These damages are awarded to deter, punish,
Future bad acts.
as an example of.
Yeah.
And that was the focus of taking this just huge bucket of liability facts that we had, but then narrowing it, saying, now y'all know all the bad acts, and now you are given this very rare opportunity to actually do something about it.
Is TNT based in Texas?
They are.
So my recollection is TNT's underlying policy was a small percentage of the ultimate judgment. Any sense of why they didn't want to cough that up?
I mean,
I assume they're going to say they didn't like you, they didn't like Tonis.
Well, for the reasons I think Ryan's already said, they just didn't have the same value on the case. That
I think that there was an arrogance on their part of both liability and on damages, that the jury put in their face, saying you're absolutely wrong. That they just viewed the case very differently than us. And I remember leading up to trial asking Tony, I was like, Tony, what are we missing? Why is the jury...
That's the crazy thing, right? Like, I see a case one way, and I see it that way for a year and a half. Then I go mediate it with a guy like Peter. And Peter says, Con, have you thought about,
Right.
have you thought about this? And then either I settle the case or I go into trial and I start drinking my own Kool-Aid and I start going down the trail. And I start thinking I'm going to win. And that's always the interesting thing, where the rubber meets the road of how I've evaluated the case for years and years, especially in the light of like good mediators like Peter. And you think, well, I mean, what am I missing? Why are all these good lawyers on the other side seeing this case different from me? Or are they just totally full of it as a tactic, right? To push the value down.
Right.
And that's obviously what makes the difference between a good trial lawyer and a great trial lawyer, is to see through that. And I mean, clearly that's where the rubber meets the road in this case.
So I asked Tony that question. I said, what are we missing? And he said, Pig, sometimes they get it wrong.
Sure.
And we just got to buckle up and get ready for trial and do our very best. But sometimes they get it wrong. We're not missing anything.
Yeah, that's absolutely true. I say that all the time. Not every case has to settle, and that's why we have so fortunate to have juries that can resolve that difference of opinion for us. And
that's not what he says to me in my cases. Normally he says, Kyle, you're an idiot. Take the money, walk away.
Never. Okay, so we'll probably kind of wind it down. Well, one of the reasons why Kyle probably didn't get to see the punitives close is everyone was tuned in at 8 a.m. when we were told it was going to start.
Yep.
And then it didn't end up starting till like 11. And that was because they filed an emergency motion for sanctions and mistrial and all kinds of things over some social media posts. So how did that go down? Did you argue that? And it's all public record, so it's not like you're revealing any confidences. So how did that thing go down? How was it argued? What did the judge do?
The judge asked for Mr. Buzbee, Tony specifically, to discuss it with the court. So I was going to argue it until judge made it clear that she wanted to hear from Tony. Tony handled it. He did a master class on handling it. Tony knows those rules of professional responsibility better than anyone in Houston when it comes to social media and what you're allowed to say and not allowed to say, given the breadth of the types of cases our firm handles that get national attention. And he didn't violate any of the rules. This was a Hail Mary from a group of people that had just been punched in the face and were looking for any way out. And this was their last-ditch effort of trying to get out.
And who argued it for them?
Judge Moore.
And Judge, the presiding judge over the trial, she denied it from the bench, and y'all went forward?
She took it under advisement. I thought one of the things Tony did so well was to frame the issue correctly, because they were pretty cute about how they filed it. What they were basically saying is that the jurors had committed misconduct by reading Tony's social media posts, because the only way his post would actually be harmful is if the jurors read it. And she picked up on that quickly when Tony framed it that way, and she brought out every juror and polled them, asked them, have you reviewed any social media? Have you seen anything about this case? Have you read anything that has influenced you in any way? And all of them, of course, said no, because they followed the instructions that are given to them every day that they're not supposed to read.
I'll be honest, as a person who follows Tony's social media, it's a deep dive to care about anything that I post or Tony posts or you posts.
Sure.
Or Peter. You got
The average person who's not in the legal business?
Yeah, I mean, you got to want it.
Yeah.
And most people just aren't that interested in anything that you or me or Tony say, which is probably appropriate considering what kind of boneheads we are.
Yeah, I mean, Tony has a large following. I mean, he's a nationally known trial lawyer, but we knew as soon as they filed it that there was no chance that this jury read what he had written, because they were going to follow the rules. This jury was phenomenal. They were locked in from day one. It is clear from their verdict. They spent, based on the questions, our best estimate is they spent about 8 to 9 hours deliberating on the value of human life question number 4. And the numbers that came back made it clear that it was very calculated. This wasn't them just pulling random numbers out of a hat, like 50 million here, 20 million here. They really thought about what they did. And I felt no heartburn or stress at all about that motion because I knew when she asked each of them, had you looked at social media, they were all going to say no. I knew that.
Was that an open court or?
She only allowed the lawyers to attend. She turned off the live stream and she brought them out individually and locked the door so that it would only be the lawyers and the jurors.
So what is next? Entry for judgment pricing?
Yes.
And so what is that as scheduled and set for that yet?
The court made it very clear that she wants an aggressive schedule and wants it entered in less than 30 days. So that was 1 or 2 weeks ago. And we're in the process of getting that filed and handled.
Got it. Okay. Kyle, anything else?
Great job. I loved watching it. I thought you guys did a great job. I am kind of better friends with you than I am with Tony, but I was impressed with everything that you guys did. Really enjoyed watching it. I took a lot of notes. I know on both of your closings with regard to regular damages and punitive damages, and take heart. Even though the defense sometimes sees the case different from you, and don't want to pay you, doesn't mean you should give up. You got to keep fighting, and you guys did a great job. I'm impressed.
All right. Well, Ryan, obviously, people that want to find you can go to txattorneys.com, see all the lawyers there, the Buzbee firm. Any other places they can find Ryan Pigg?
Yeah, I've got my own website, ryanpigglaw.com, and I'm on Instagram and other social media stuff. It's pretty easy to find me with my last name being as unique as it is.
Yeah, and lawyer
squealpigsqueal.edu. That's like it's you and the University of Arkansas, but you guys have
the Razorbacks and I sometimes butt that.
Yeah, that's fine. I appreciate it.
Yeah, but I assume lawyers that want to know more, this has been very informative, but want to know more, have specific questions, I'm sure, feel free to give you a buzz.
Absolutely. I mean, this is one of the most significant things that's happened in my career. It happened on the 10-year anniversary of me being at the firm and working with Tony, and I'm just so damn proud of what our team did. I thought all of us operated at such a high level. David, Tony, Colby, even our interns, Anna and Bien, everyone came together and just operated at such a high level. I couldn't be more proud of where I work and who I did this case with.
Congratulations.
Yeah, I was there on day one of the Pigg regime at the Buzbee Law Firm, and it's come so far. I'm so proud.
There you go.
Yeah. All right. Well, Ryan, thanks a lot for joining us. That was very, very good, very informative. If you like this, we're going to try to get it out quick, because this verdict just happened last week. So if you like this, follow us on Instagram, Spotify, LinkedIn, Apple Podcasts, TikTok, not X, but all the social media.
MySpace.
Places. Yeah, I don't have Bill here to promise.
No Truth Social.
No.
LinkedIn.
Try to keep it elegant, very correct. Yeah, follow us on that, and you can always see this episode and others as we go along. So thanks for joining us, and
thank you.
You good night. Thank you, Ron.